DOJ moves to crush California sanctuary state policies, by Amy Moreno for truthfeednews.com. Time's up for California and their brazen, lawless sanctuary state policies. The DOJ is fighting back and will challenge the constitutionality of 3 of the state's laws which protect criminal illegals. From Breitbart, Attorney General Jeff Sessions will speak Wednesday about his Department of Justice's DOJ first-of-its-kind lawsuit challenging the constitutionality of 3 of California's sanctuary, quote, laws, Breitbart News has learned. Relying on both federal statutes and the U.S. Constitution's Supremacy Clause, DOJ will ask the U.S. District Court for the District of Eastern California to issue a preliminary injunction blocking the enforcement of these laws intended to protect illegal aliens by preventing cooperation with federal immigration enforcement. DOJ will also seek declaratory judgment that these laws are unconstitutional, preempted by federal immigration law, when it files late Tuesday night. The Department of Justice and the Trump administration are going to fight these unfair, unjust, and unconstitutional policies that have been imposed on you. Attorney General Sessions is expected to tell a gathering of California police officers Wednesday in Sacramento. We are fighting to make your job safer and to help reduce crime in America, and I believe that we are going to win. A DOJ official made clear that he believed the laws intentionally created obstacles for federal immigration enforcement in California, the state with the most illegal aliens in the country. The defendants are the state of California Governor Jerry Brown and California Attorney General Xavier Becerra, the elected official who perhaps more than any other has made protection of criminal illegal aliens and, quote, resistance to President Trump's immigration agenda his signature policy. The doctrine of preemption dictates that as federal law reigns supreme over state law, states may not enforce laws that frustrate federal policies. It has a long history dating back nearly to the dawn of the Republic, with 1819's McCulloch versus Maryland. In the immigration context, the doctrine was widely heralded by open borders advocates in 2012, when the Supreme Court relied on it to strike down sections of Arizona's tough SB 1070 anti-illegal immigration bill in Arizona versus the United States. The legal shoe is on the other foot now, as the Trump administration seeks to have California's leading-edge sanctuary laws overturned on a similar theory. All 3 laws passed in response to Trump's victory in the 2016 presidential election added new dimensions to California's role as the nation's leading sanctuary for illegal aliens. Not content with being merely a typical sanctuary jurisdiction, where as a matter of policy, police do not contact U.S. Immigration and Customs Enforcement ICE agents about suspected illegal aliens, collect information on an arrestee's immigration status, or comply with requests to hold suspected illegal aliens for ICE pickup. California enacted HB 450, SB 54, and HB 103. HB 45 came into effect at the beginning of the year. It prohibits private employees from cooperating with ICE. Under the law, if employees do not refuse to allow ICE officials onto their property without a warrant, they face stiff fines. If they try to check an employee's immigration status a second time, they face fines. If they do not inform employees of ICE enforcement efforts about which they know, they face fines. During the first round of ICE raids after HB 450 went into effect, Becerra was very clear that his office will prosecute employees who cooperate. A senior DOJ official told reporters if the federal agency involved have been the FBI rather than ICE, a law like AB 450 would be inconceivable. He feared that given its broadest reading, it might prohibit all property owners from assisting federal immigration enforcement. In the case of HB 450, the California State Assembly's Judiciary Committee made clear they were passing this law specifically because of an expected increase in federal immigration enforcement. SB 54, also coming into effect January 1st, affects law enforcement officials holding them statewide to the sanctuary, quote, standard previously in place in cities like San Francisco under penalty of state law. HB 54, California's police officers and sheriffs cannot provide ICE with the release dates of the criminal illegal aliens whom they are holding, except for those held for a narrow set of serious crimes. These law enforcement officers cannot transfer detainees to federal custody voluntarily. Finally, AB 103 is a 2017 law Becerra has used to inspect, quote, facilities the Department of Homeland Security uses to house suspected illegal aliens who are awaiting removal proceedings. DOJ believes these inspections have demanded access to proprietary DHS documents and information. The government will first seek to have a preliminary injunction put in place to block enforcement of all three laws while their constitutionality is considered. DOJ will therefore have to show some irreparable harm that will come from allowing California to use these laws in the meantime. Senior DOJ officials were confident that with a typical briefing schedule, they expect a ruling on their preliminary injunction within weeks. Well, I think they're going to take care of this. Sessions will, because Sessions, the only thing he knows how to do is go after pot smokers and the illegals. The real criminality that is destroying this country totally, he's not going after. But again, it's one step in the right direction that he is taking, but this is not what we want only to be seen, because this is peanuts in comparison to what's going on, because California is a mess already. But at least he should be doing his job prosecuting Hillary and Obama and the rest of the gang there. Let me know what you guys think in the comments below, and again, thank you so much for watching.